May 12, 2023 Unit 13 Land Use Controls 1. The power to zone was given to cities and counties by A. The U.S. Constitution. B. The 13th Amendment. C. Enabling Acts. D. The U.S. Supreme Court. Answer C. Enabling Acts. 2. Least likely to be upheld by California courts is rezoning that would A. Eliminate any beneficial use of the land. B. Result in a reduction of value. C. Reduce the use density. D. B. Downzoning. The least likely to be upheld by California courts is rezoning that would A. Eliminate any beneficial use of the land. This type of rezoning would likely be considered a regulatory taking, which would require the government to compensate the property owner for the loss of use of their property. The other options listed may be upheld by California courts depending on the specific circumstances and the reasonableness of the zoning decision. 3. Zoning that allows a single-family home to be built in an area zoned for apartments is an example of B. Cumulative zoning. Cumulative zoning allows all more restrictive uses. For example, an area zoned for multiple family use would allow single-family homes as well if the zoning were cumulative. 4. Covenants differ from conditions in that breach of a B. condition could result in forfeiture. Covenants are private, voluntary restrictions that run with the land. They are promises among landowners that are mutually enforceable. The remedy for a breach of a covenant will be damages or an injunction. Conditions differ from covenants in that they create a defeasible estate. A breach of a condition subsequent means that title will be lost. Usually it will revert to the original grantor or his or her heirs. Because of the harsh penalty of forfeiture, courts will construe conditions narrowly and, if at all possible, will determine that a covenant rather than a condition was intended. 5. Zoning that prohibits adult entertainment within an area is B. Exclusionary zoning. 6. Zoning for density is known as B. Bulk zoning. 7. Which is true of a non-conforming use. C. It was illegal use before zoning. 8. New zoning that prohibits an existing use would not provide for A. Immediate closure. B. The time period for closure. C. Prohibition of expansion. D. Continuation of use by a non-conforming user. Not provide for D. Continuation of use by a non-conforming user. 9. The most likely action for violation of a deed covenant would be A. Action for injunction. An injunction is a legal order issued by a court that requires a person or entity to stop engaging in a specific activity or behavior. It is a type of equitable remedy that is typically used to prevent harm, protect rights, or enforce the terms of a contract or legal agreement. In the context of real estate, an injunction can be used to stop a property owner from engaging in activities that violate a covenant, zoning law, or other legal requirement. 10. Which is true of restrictive covenants. A. They run with the land. B. If not recorded, they are not binding on a subsequent purchaser without notice. C. They are usually negative covenants. D. All of these are true. D. 11. Deed restrictions are created by D. The grantors. 12. A copy of the CCRs requested by an owner in a condominium, cooperative, or community apartment project must be furnished within A. 10 days. A copy of the CCRs, covenants, conditions, and restrictions, requested by an owner in a condominium, cooperative, or community apartment project must be furnished within 10 days, according to California law. 13. Which CCR would most likely be enforceable? D. One that requires property to be used only for religious purposes. Restrictions that prohibit or discriminate against protected classes, such as race, religion, national origin, etc., are illegal and unenforceable under the Fair Housing Act. Restrictions that limit the right to transfer or sell a property are generally disfavored by courts, but they may be enforceable if they are reasonable and not contrary to public policy. A restriction that requires the property to be used only for religious purposes would likely be seen as reasonable and not contrary to public policy, and therefore enforceable. 14. The Subdivision Map Act is concerned with A. Physical aspects of the subdivision. 15. The Subdivided Lands Law is concerned primarily with C. Protecting purchasers. 16. The Subdivided Lands Law does not apply to A. California subdivisions. B. Nevada subdivisions sold in California. C. Division into 4 parcels for the purpose of sale. D. Condominiums. Answer C. Division into 4 parcels for the purpose of sale. The Subdivided Lands Law is a California law that provides regulations for the sale of certain types of real estate subdivisions, such as those that are divided into 5 or more lots, parcels, or units for sale or lease. The law is designed to protect buyers from fraud, misrepresentation, and other unethical practices in the sale of subdivided lands. The law requires developers to provide extensive disclosures to potential buyers, including detailed information about the property, the terms of the sale, and any risks associated with the purchase. Developers must also obtain a public report from the California Department of Real Estate before offering subdivided lands for sale. 17. When 3 1-acre parcels are to be sold from a 9-acre parcel each year for 3 years, the sellers must comply with A. The MAP Act. B. The Subdivided Lands Law. C. Both of these. Answer C. Both of these. 18. The Subdivided Lands Law covers A. Undivided interests. B. Out-of-state subdivisions sold in California. C. Timeshares. D. All of these. D. All of these. The Subdivided Lands Law covers undivided interests, out-of-state subdivisions sold in California, and timeshares. 19. The Subdivision Map Act applies to B. 2 or more parcels. 20. Public reports expire c. 5 years from the date of issuance. 21. A subdivider who has not received a final public report but is able to enter into binding contracts with purchasers has a B. Conditional public report. 22. 7 parcels of land were subject to a restrictive covenant limiting use for residential purposes. A woman acquired all 7 parcels and intends to build a commercial property in conformance with zoning. Which of the following describes her rights? B. The restrictive covenant is terminated by merger. The correct answer is B. The restrictive covenant is terminated by merger. When one owner acquires all the parcels subject to a restrictive covenant, the covenant is said to be merged and is no longer enforceable. In this case, since the woman has acquired all 7 parcels, the restrictive covenant limiting the use of the property for residential purposes is terminated by merger, and she is entitled to build a commercial property in conformance with zoning. 23. Which is true of the Interstate Land Sales Full Disclosure Act? C. The California Public Report can be used to satisfy the disclosure requirements. The Interstate Land Sales Full Disclosure Act, ILSA, is a federal law that requires developers of certain real estate developments, primarily subdivisions, to register with the Consumer Financial Protection Bureau, CFPB, and provide detailed information about the development to prospective purchasers. The law applies to developments consisting of 100 or more lots, and it requires developers to provide purchasers with a property report containing information about the development, the developer, and the terms of the sale. The law also provides purchasers with a 7-day right of rescission, during which they can cancel the contract without penalty. 24. The statute of limitations for builder liability is A. 4 years for patent defects and 10 years for latent defects. 25. Excluded from strict liability for defects are D. Subcontractors. Unit 14. Escrow and title insurance. 1. After escrow instructions have been signed, the escrow agent may C. Refuse to obey instructions received from the broker. Because the real estate broker is not a party to the escrow agent cannot change the escrow instructions at the direction of the broker. 2. If escrow instructions fail to provide for the date of possession, possession will be given C. At close of escrow. 3. An amendment to the escrow instructions requires the agreement of A. The buyer and the escrow. B. The agent and the escrow. C. The buyer, seller, agent, and escrow. D. None of these. Answer D. None of these. Buyer and seller agent is not a party to escrow. 4. When the signed escrow instructions differ from the purchase agreement, A. The escrow takes precedence because it is signed later. 5. Duties of an escrow do not include A. Ordering preliminary title reports. B. Mediating buyer-seller disputes. C. Drafting deeds. D. Issuing closing statements. Answer B. Mediating buyer-seller disputes. 6. Exempt from the licensing requirements are escrows conducted by a real estate broker in transactions in which the broker represents either the buyer or the seller. B. Title insurance companies. C. Banks. D. All of these parties. Answer D. All of these parties. Licensing escrows must be licensed by the Commissioner of Corporations, exempt from the licensing requirements of the escrow law, or A. Banks and savings associations. A. Title insurance companies. A. Attorneys. Attorneys essentially are unregulated unless they operate an escrow company. However, they must have had a bona fide client relationship with one of the parties. And A. Real estate brokers. This exemption applies only to transactions where the broker was either a principal or the listing or selling agent. Individuals cannot be licensed as escrows. Escrows must be corporations. 7. A real estate broker, not licensed as an escrow, can conduct an escrow when the broker is A. A representative of the seller. B. A representative of the buyer. C. A principal to the transaction. D. Any of these. Answer D. Any of these. 8. Which actions of an escrow would be improper? A. Accepting fees from both buyer and seller. B. Refusing to pay a commission for referral to the escrow. C. Refusing to handle an escrow. D. Accepting escrow instructions with blanks to be filled in by the escrow after the instructions are signed. Answer D. Accepting escrow instructions with blanks to be filled in by the escrow after the instructions are signed. 9. Which behavior is proper for a broker who, while not licensed as an escrow, conducts escrows on the broker's sales? C. Charging for the escrow services. 10. A buyer given possession by the seller 1 week before close of escrow should be most concerned about A. The impound account. B. Risk of loss. C. Extended title coverage. D. Designation of the escrow holder. The buyer given possession by the seller 1 week before close of escrow should be most concerned about the risk of loss. It generally passes with possession. 11. Which statement is true of the rights and obligations during escrow? A. The seller retains risk of property loss. B. Rents belong to the seller. C. Property expenses are the responsibility of the seller. D. All of these are true. Answer D. All of these are true. 12. Which would not terminate an escrow? C. The broker's order to terminate. 13. When both buyer and seller make demands on escrow for the buyer's deposit after the escrow failed to close, the escrow holder should A. Deduct its fees and return the deposit to the person who made it. B. Deduct its fees and return the deposit to the seller. C. File an interpleader action. D. Give the deposit to the first party making a claim to it. The correct answer is C. File an interpleader action. When both the buyer and the seller make demands on the escrow for the buyer's deposit after the escrow fails to close, the escrow holder should file an interpleader action. In this action, the escrow holder deposits the disputed funds with the court and asks the court to determine who is entitled to the funds. This protects the escrow holder from any liability and allows the court to make a determination as to who is entitled to the funds. 14. Which best describes an abstract of title? A. The complete legal description. B. An abbreviated description, such as a street address. C. A recorded history of title. D. An opinion of title. An abstract of title is a recorded history of title, which provides a summary of all recorded documents that affect the ownership of a particular property. Therefore, the best answer is C. 15. Which is true regarding title insurance? A. Executors and heirs are protected by the title insurance of the deceased insured. 16. A title insurer will not be liable for a loss if A. Its negligence was not the cause of the loss. B. The person suffering the loss was not the insured or the insured's estate or heirs. C. Either of these occurred. D. Neither of these occurred. Answer: the person suffering the loss was not the insured or the insured's estate or heirs. 17. To issue a standard title policy, the insurer must A. Provide a survey. B. Determine whether title is good. C. Provide an abstract. D. Do none of these. D. Do none of these. 18. Which is true of the preliminary title report? A. It provides interim coverage. B. It shows the condition of title. C. It provides no insurance. D. Both B and C are true. Correct. The statement both B and C are true is true regarding the preliminary title report. The preliminary title report shows the condition of title, including liens, encumbrances, and other matters that affect the property's ownership. However, it provides no insurance but provides interim coverage, which means that it is subject to change based on any new information or documents that come to light during the escrow process. 19. A standard policy of title insurance protects against a. Rights of parties in possession. B. Unrecorded easements. C. Zoning restrictions. D. Forgery in the chain of title. Answer, D. Forgery in the chain of title. Explanation. A standard policy of title insurance protects the owner against financial loss resulting from title defects and encumbrances that existed prior to the policy date, such as forgery, undisclosed errors, mistakes in recording legal documents, and inadequate surveys. The policy is based on a search of public records and provides coverage up to the policy amount for the insured's loss or damage sustained due to title defects or encumbrances, subject to the policy's terms and conditions. 20. A standard policy of title insurance does not cover a. Unknown spousal interests. B. Rights of parties in possession. C. Forgery. D. Lack of capacity of the grantor. Answer B. Rights of parties in possession. 21. A standard policy of title insurance covers a. Unrecorded mechanics liens. B. Instruments outside the chain of title. C. Easements that are not a matter of public record. D. None of these. Answer, D. None of these. Explanation. A standard policy of title insurance provides coverage for certain risks related to the title of the property, such as forgery, lack of capacity of the grantor, and undisclosed heirs. However, it does not cover unrecorded mechanics liens, instruments outside the chain of title, or easements that are not a matter of public record. These risks may be covered by an extended policy of title insurance or may require additional documentation or disclosures. 22. After buying a home and receiving a standard policy of title insurance, you determine that the tenant claims to be an owner under an unrecorded grant deed. Which statement is true? A. You are protected by your insurance. B. If you record first, you will be protected. C. You are not insured for this loss. D. An abstract would have given you greater protection. C. You are not insured for this loss. A standard policy of title insurance only covers the defects that are listed in the policy. An unrecorded grant deed is not covered by a standard policy of title insurance, and the policyholder is not protected against a claim by a party who is not named in the policy. In this situation, the buyer would need to take legal action against the tenant to resolve the dispute. An abstract of title would not have given greater protection in this case, as it only provides a history of the property's title and does not insure against defects. 23. Extended coverage. Homeowners title insurance adds which element to the coverage of the standard policy? A. Forgery. B. Unknown spousal interests. C. Lack of capacity. D. Water rights. Extended coverage. Homeowners title insurance adds water rights to the coverage of the standard policy. 24. Extended coverage policies of title insurance do not generally cover a. Claims of a party in possession. B. Building and zoning regulations. C. Prescriptive easements. D. Water rights. Extended coverage policies of title insurance generally do not cover building and zoning regulations. Option B. 25. The rebate law prohibits a. Escrows from giving rebates to brokers. B. Title companies from giving rebates to brokers. C. Brokers from rebating commissions to buyers. D. Both A and B. Answer D. Both A and B. Unit 15 Landlord-Tenant Law. 2. A tenancy for years must be created by a. Express agreement. 8. Which statement is true regarding the assignment of a lease? D. The entire leasehold is transferred. D. The entire leasehold is transferred. In an assignment of a lease, the assigner transfers their entire leasehold interest to the assignee, who becomes responsible for all of the obligations and benefits of the lease for the remainder of the term. The original lessee is typically released from any further obligations under the lease. 10. An assignee of a lessee has a relationship to the lessor of B. Tenant. An assignee of a lessee is someone who takes over the lease from the original lessee, becoming responsible for paying rent and fulfilling all other obligations under the lease agreement. The assignee does not have a sublease relationship with the lessor, but rather becomes a tenant with a direct relationship to the lessor. 11. A tenant on a long-term lease purchased the premises from the lessor. Later, to raise cash, he sold the property to an investor, who gave the tenant a 30-day notice to vacate. What are the rights of the parties? C. The purchase by the tenant ended the lease. Lease terminated by merger. 17. When one residential tenant attacks another tenant, is the landlord liable? C. Probably, if the attack was foreseeable. 18. A 3-day notice to quit or pay rent could be used against a tenant who a. Violated a lease provision. B. Was delinquent in rent. C. Used the premises for an illegal purpose. D. Did all of these. Answer B. Was delinquent in rent. Others would be quit or cure. 19. After a landlord has served an unlawful detainer action, the tenant B. has 5 days to answer the charges. 20. When a tenant abandons the premises with 3 years remaining on the lease, the landlord may not a. sue for the balance due on the lease.